Hola, buenos días. Soy la abogada Helen Tarokic. Hi, I'm attorney Helen Tarokic. I work in Wilmington, North Carolina, and I'm here to talk about what do you do if your DACA renewal is delayed. Hablo de diferentes temas de migración. Soy abogada de migración en Wilmington, North Carolina, y estamos aquí para hablar sobre qué pasa si su renovación de su acción diferida de estudiantes, que se llama DACA, es demorado. Ok, vamos a ver si hay preguntas. Vamos poco a poco, paso a paso, por este proceso. Otra vez, yo soy la abogada Helen Tarokic. Estoy usando nueva tecnología para este streaming. Estamos en vivo en YouTube y también estamos aquí en vivo en Facebook. Si le gusta la presentación, puede ponernos un like, seguirnos en Facebook o ser un follower en YouTube o subscribe. Y también en Facebook puede mandar estrellas que se llaman Sending Stars si le gusta la información o si puede ayudar a otros. So if you appreciate the information that we're going to share today, please do consider sharing, following, giving us a like, or in Facebook, you can also send stars. So again, my name is Helen Tarokic. I'm a North Carolina board certified immigration law specialist. I'm an attorney. Our law office is based in Wilmington, North Carolina. I can take questions in English and Spanish. For today, our presentation was planned to be in English, but of course, if you want to put your questions in the Facebook chat, for example, I can try to answer those questions in Spanish as well. As always, this is not specific legal advice. We go through hypothetical scenarios. To have specific legal advice, you do need to be a client of our law firm or have a consultation to go over your case-specific questions. So this presentation does not create an attorney-client relationship and is also not specific legal advice. So with that caveat, I think we're just going to go ahead and begin. So I'm going to talk a little bit about deferred action for childhood arrivals, renewals, and the kind of situations we're seeing currently in the field. So I'm seeing a lot of posts about people having delayed DACA renewal decisions. And for years, I've been sounding the alarm about this because you just never know how long it's going to take for a DACA renewal to go through. But saying I told you so does not help anybody when their DACA is delayed. And I think that many years of the administration granting most DACA cases in a few months really led people to reasonably, fairly believe that it should only take a few months for their DACA to be renewed. After all, most DACA applicants have no new record. There's nothing new about their lives. They're going to go through the same background checks as they have before. And so there really shouldn't be any additional time needed for the government to grant a simple renewal application for DACA and the work authorization that goes along with it. And yet we're seeing 6 or 7 months processing times or longer for applications. Now, some of you might remember when DACA first came out in 2012 that there were some cases processed in 30 days. It was amazing. And then 3 months, and then suddenly 4 months, 5 months, 6 months. And then we saw situations where it was taking 13 months to get that first DACA approval. And then sometimes they'd approve DACA for 2 years, sometimes they'd approve it for 3 years. And the renewal times kept changing. So we tried to file DACA renewals 6 months in advance or more. After the election, and we knew there'd be a change in presidency, we thought that it would be helpful to file even a year in advance to renew DACA. The downside to filing really early for DACA means that you may get that 2-year approval before your current DACA expires, meaning you'll kind of shorten the time period, so they give you that 2-year approval, but you might already have a few months left on your current DACA approval. So it kind of feels like you paid for time you didn't get to use. But the upside to filing early for DACA, even if you are going to get an approval before your current 2-year period expires, is that you're avoiding the unlawful presence issues. You're avoiding the stress of potentially losing your employment, authorization, You're avoiding the issues with trying to then get a driver's license renewal, because sometimes just getting the work permit doesn't mean you can the very next day get into the Department of Motor Vehicles and get a renewal for your driver's license. So the benefits to renewing very early for DACA right now really do outweigh the risks of maybe having a few months less time than you had hoped, when overall they should be granting a full 2-year renewal eventually. But for those who, of course, didn't know this was going on, that there have been incredible delays lately with immigration approving DACA renewals. Um, what do you do now, right? So what do you do if you have a current DACA delay? Well, we've certainly been doing our best to help clients in this situation. And the first thing that we tend to look at is whether or not the application has any basic problems with it, right? So sometimes we get consultations where it's not a case that our law office filed. So we're looking to see if maybe the person's diploma was not from a accredited institution. So sometimes there are diploma mills where there weren't actually legitimate degrees awarded. And sometimes clients don't know this. They think that they actually completed like a short online course of study and that they did have a qualifying diploma that would be like a GED or high school diploma equivalent, only to find out that with a little bit of Googling, that the institution that granted that diploma is not a valid one and maybe even gotten into some consumer fraud problems. So there are some lists of different educational institutions out there that just aren't legitimate ones for the purpose of qualifying for DACA in the first place. So we do look at that. We also look to see whether there's any criminal history that may not have been disclosed or something that might be holding up the application in terms of like a substantive problem with it. But most of the time, what we do see is that it is a legitimate DACA application. There's no new fix related to the substantive part of the application, and what we have is just a DACA delay. So then what do we do? Well, USCIS has expedite criteria, and I'm sure many of you watching this have seen the expedite criteria online, but many of you have not, so we'll talk about that. If somebody's going to suffer, for example, extreme financial hardship, if their DACA case is not expedited to get to a decision before their current DACA expires, that's a reason for USCIS to expedite the case. But more often than not, financial hardship is not a successful basis for an expedite. It unfortunately is something that we often cannot get immigration to pay enough attention to. I think part of the perspective on that is that many people should expect to have loss of job, loss of income, problems paying the rent, problem getting a driver's license, some significant financial hardships if that work permit is not granted. So if just about everybody is delayed for DACA approvals right now, it's hard for immigration to say, okay, which financial hardship is strong enough for us to pull this one from the line and expeditiously grant it, compared to the other ones that are pending. Just the same, that doesn't mean you can't try a financial hardship expedite. I think if you do it, though, you really want to make sure that you have good documentation. So, for example, if you have a notification that employment will be ending as of the date of your work permit expiration, and you also have something that will show that your income is fairly minimal, and that you won't be able to afford like basic food or transportation or the ability to have safe housing, like pay your rent, that may work for the financial hardship expedite. But it is rough, and I know that financial expedites are really tough to get approved. It doesn't mean you can't get them approved. We've had some successfully go through, but what I usually tell people is we really need to talk about health instead. So, a second way to get an expedite on your delayed DACA application for renewal of deferred action is to request that USCIS consider the medical hardship that would fall on you or others close to you if your DACA were not renewed on time. We've had much more success with medical expedites because they are more unique, they are more personal, they are often more weighty when we explain it to immigration requesting an expedite. So, what might that mean? So, the first thing I ask clients is, do you have any pill bottles at home, medicines that you take? Photographs of those medicine bottles can be easier to obtain sometimes than a doctor's letter to explain what they are for. So sometimes we'll have our client will typically draft a letter for our client about the medical hardship that they'll experience, but medicines that they wouldn't be able to access if they lose their job, their health insurance, or don't have money to pay for those medicines, even if they didn't have health insurance in the first place. That is like one of the number one things that we're talking about because continuity of medication can be critical. Um, Even for some, I would consider to be like light medications, having to end your medication like cold turkey can have deathly effects. So I'll give you an example. Wellbutrin is a common anxiety medication. I think it also has some implications to like help with smoking cessation, to quit smoking, some other things. So if you're taking Wellbutrin, even a low dose, that's not like something that people look at as like a life-saving medicine, right? It's not cancer treatment. But if you explain in the letter that not being able to afford your next Wellbutrin prescription for the month, if your employment ends due to Daca delays, well, you can't explain that the consequence of cold turkey, like quitting immediately that medication without being able to taper it down, the consequences to that can be significant. Now, I'm not a doctor, but you can go ahead and Google what the consequences are of quitting medication cold turkey. Oftentimes, it can be death, suicidal ideation, headaches, trouble breathing. There are lots of different things. I'm not talking about the specific medication right now, but there are a lot of things that you can pull up related to from the website of that uh, manufacturer of that medication that will show you what the warnings are related to having to end medication. So I would suggest if you're talking about a medical expedite that you not just say, um, again, not legal advice, but as an attorney, what we're often looking at is we're trying not to just say this person needs this type of medication for diabetes or for blood pressure or for cholesterol or for anxiety, but the consequences of losing that medication would have severe, even potential death consequences to the person if they can't access it anymore. In order to do an expedite request, you're typically going to need to call USCIS and put in the request. And then they'll usually give you an opportunity to mail in the related documentation for the medical expedite. If you don't have any documentation to send them, not a bill, not a receipt, no pill bottles, no letter from a doctor or a clinician, it's really hard to get the medical expedite to go through. There's usually communication that happens related to emailing or mailing in that supporting documentation, just depends on what customer service is requesting that day. And then eventually you'll hear back related to it. And of course, for those of you who are doing online filings, then there may be uploads and uploaded notifications there with your final answer. So if the medical expedite is not immediately successful, you can simultaneously pursue congressional liaison requests. So regardless of political affiliation, each senator and House of Representatives in the federal government, those representatives, your congressional representatives, have a constituents assistance program. And regardless of your inability to vote as a DACA holder, you're still a constituent that those senators or representatives cover. So there's a Privacy Act release form that needs to get filled out and signed by you. You want to make sure that you're the one signing it. It cannot be just passed off to someone else to sign for you. If signatures don't match up, then there's going to be an issue with processing your request. But the Privacy Act release form is about giving permission to the senator's office, for example, to communicate with USCIS on your behalf related to the expedite request. If you don't sign that form, they cannot communicate with USCIS for you, and your congressional request will go nowhere. When you sign that form and you're emailing back and forth with your congressional representative about this, again, you're going to want to focus typically where possible on your medical expedite. You can also add in hardship. You can give more than one explanation as to why you need the expedite. And then hopefully you will hear back. But it is nothing fast. The expedites are not things that typically happen overnight. Most of the time, you could still be waiting a month before, and there could be weeks of back and forth before you get something back from USCIS on it. So if you don't have a decision on your DACA renewal and your status is about to expire in a month or less, and you haven't tried an expedite and think you were qualifying for one, it's time to probably move forward with that. Another tip, please, if you have an immigration attorney handling your DACA, don't go do expedite requests on your own pro se without your lawyer's knowledge. You can really screw up your case by double dipping into systems, sending incorrect information, going behind your lawyer's back, essentially, and sending in documentation to the immigration service that they have not reviewed or have no knowledge of. So it really should be a collaboration between the DACA client and their law firm that is representing them to submit any expedite requests. I cannot tell you how many times I have seen clients send us information they think will qualify for an expedite request, and it's not our client's fault, but it's poorly written. It doesn't even really explain what is needed for the expedite. It doesn't match the very specific buzzwords or criteria that USCIS needs to hear. So, with accurate information, with truthful information, and qualifying for an expedite, you have a better chance of getting it granted. If you haven't been clear, you don't have backup documentation, it's poorly explained, then you're less likely to be successful with an expedite. I will tell people, even with an expedite request, sometimes we're just not successful anyway. It does feel like a coin toss. I've had things expedited for some clients that I didn't think the situations were as serious as they were for others, but everybody still qualified for the expedite. So sometimes it just feels unfair that no matter how well our client and we do, we don't get the expedite to go through. But overall, if it's done well, there's nothing to lose by trying. A couple other things I wanted to mention about expedites. Y entonces voy a contestar las preguntas que están en el chat de Elena y de Elizabeth, Elibeth. Muchas gracias por estar aquí hoy. Solo un minuto para que conteste esta parte del expedite de que estoy hablando en inglés. So I'll answer two Spanish questions in a moment. Women issues. So ovarian cysts, situations with endometriosis, sorry. People who have had biopsies and are waiting for results. Anything related to the female system or female reproductive system that are medical issues, I would highly suggest truly emphasizing that as much as you can. I'm not sure if USCIS expedite officers actually understand medical terminology related to women, but I have seen that when we are talking about those issues, those expedites tend to go through. It's great that there's some sympathy or understanding there. Sometimes I wonder if they did understand, or were they just like, lady issues, I'm going to go ahead and grab this expedite because I don't want to deal with this topic. I don't know. But I would just suggest, if you are a woman and you need a DACA expedite, that you talk to your OBGYN or to your gynecologist and see if they can write a support letter for your expedite, possibly. If you are in need of testing or biopsies or something like that, it could be very helpful to get that information and include it for your expedite request. Oftentimes, women do not get the care that they need. And so now is as good a time as any to reach out to your healthcare provider to have a review to make sure that if there are any medical issues, those can then be brought up in your medical expedite, honestly and ethically. So please, if you haven't had an eye exam, get the eye exam. Maybe there is something there that actually is a medical issue, and then use that for your expedite request. The same with dental stuff. So many clients need teeth pulled or dental surgery or other major things that they can't afford right now. Get the letter from the dentist recommending what you need done, and then use that for your expedite. And once you get your work permit, then go back to the dentist and get that work done if you can. So you want to make sure that you're thinking about health in terms of mental health, medical health, optical, eye care, dental care, any type of medical issue, very broad. These can also be things like educational disabilities. That's like an educational and medical disability. And you can take a look at what's going on with your kids or other household members that depend on you for payment of those medical care um, bills or driving them to therapist appointments. So, for example, a child with autism who sees multiple specialists per month, the parent needs to be able to get them to those sessions. And so there's that kind of a thing as well. So the medical expedite is one of the strongest things that you can do to try to expedite your DACA. I hope this has been helpful. If it has, please give us a like, a follow, or subscribe. And also, we appreciate stars. Okay. Ahora, we're going to do some questions in Spanish next. Ahora, hay una pregunta. Abogada, buenos días. Mi hijo tiene DACA desde los 15 años, ahora tiene 25. Él ha estado renovando y le llegaba el permiso sin ningún problema. Su récord está limpio y nada ha cambiado, pero esta última vez renovó en noviembre y el permiso no le ha llegado. ¿Hay algo que se puede hacer para acelerar el proceso o solo quiere esperar? Muy buena pregunta. Eso sí es un problema para muchas personas. Los tiempos de procesamiento de DACA han tomado demasiado hoy en día y muchas veces no es por ninguna razón. Nada ha cambiado, como usted dice, y simplemente UCES está lento. Una opción es hacer una demanda, una queja en Corte Federal que se llama mandamus, pero típicamente esto cuesta tanto que gente no lo quiere usar y entiendo eso. Otra opción para su hijo sería considerar si puede hacer un pedido a su congresista, se llama Congressional Liaison Expedite Request. Es un pedido a, por ejemplo, la oficina del senador, a ver si ellos pueden acelerar el proceso por pedir a inmigración, a ustedes, si lo pueden mover más rápidamente. Tiene que calificar para un proceso de agilización si lo va a pedir. Típicamente pidiendo para que lo agilicen simplemente debido a la situación económica no es lo suficiente, aunque es una opción. Normalmente, en vez de esto, nosotros estamos buscando a ver si hay medicamentos que él necesita o tratamiento para su salud mental o si necesita ayuda con lentes o otra salud de los ojos. Si necesita una cirugía o algo que tiene que ver con los dientes que no puede pagar sin que renueve su DACA. Así que cualquier situación médica que él tiene, o añadiendo diferentes situaciones para tener pruebas de algunos biles médicos o una carta del proveedor. Esto puede ser incluido en el pedido. Típicamente la carta dice, necesito una agilización de mi proceso de DACA porque si se vence mi permiso o si ya se venció el permiso, entonces no puedo ni manejar ni pagar para este cuidado que necesito, como lo que él describía de cualquier tipo de ayuda médica. Esto es muy importante intentar y lo puede hacer por llamar a inmigración para pedirlo y de ahí mandar los documentos de agilización como bajo las instrucciones de la gente en la línea de servicio telefónica de UCES. O puede pedirlo a través de la oficina de congresista. En su web sitio de cada congresista hay algo que se dice que se llama Congressional Liaison o Constituent Assistance, donde puede llenar un pedido y firmar un formulario para poder procesar el pedido. Significa, en inglés se llama Privacy Act Release Form. Y este video que estoy haciendo en vivo va a ser una grabación en YouTube en vivo y en Facebook. Así que, señora Elena, si quisiera demostrar a su hijo lo que estoy diciendo en video, a lo mejor ya para esta noche o mañana podría mirar esta parte del video sobre eso del Privacy Act Release Form. Ahora, si su hijo ya tiene un abogado, es importante que él use su abogado, por favor, para pedir agilización del servicio de migración y de liaison de congresista, porque no queremos interrumpir representación del abogado o hacer algo que sea un mal sorpresa o incorrecto. Por supuesto, no puedo dar consejería específica en este YouTube y Facebook en vivo, pero estas son cosas generalmente que gente puede hacer. Él puede también estar quedando en espera simplemente, pero muchas veces esperando y esperando no ayuda mucho tampoco porque no sabemos cuánto más van a ser las demoras de acción diferida de estudiantes. Encima de esto, si alguien tiene una orden de deportación en su contra, si fueran, por ejemplo, detenidos en la frontera alguna vez o tiene una orden de deportación bajo su número A, si se vence su Daca, entonces queda como sin protección de remoción, así que sería importante también mirar el número A en el sistema de EOIR, a ver si hay algún récord bajo su número A, su número de extranjero. Esto también sería importante vigilar. Gracias por su pregunta, señora Elena. Me encanta su nombre, muy parecido al mío. Y también por tener la primera pregunta, le agradezco muchísimo. Es mucho más fácil enseñar cuando tengo muy buenas preguntas. Espero que todo salga bien con su hijo. The question was if somebody has a child who's had Daca since they were 15 and they're now 25. They've always renewed without a problem. What could they possibly do? Should they just wait? And my answer was we need to look again at the medical expedite or financial expedite or other USCIS expedite criteria, and then contacting USCIS with the correct documentation for the expedite would be important, or at least trying it through your senator's office, like congressional liaison assistance. Ok, otra pregunta, Elibeth Navarro, gracias por estar aquí escuchando y tan paciente también. La pregunta es, abogada, mi DACA se venció hace ya 4 años, ¿qué puedo hacer? Ok, muy buena pregunta. Vamos a contestar esto en inglés y también en español. Ok, so la pregunta es, mi DACA se venció hace 4 años, ¿qué puedo hacer ahora? Esto es una pregunta fantástica, fue algo que yo quería cubrir hoy también. Si alguien ha perdido su DACA anteriormente por fraude o mala consejería o porque lo perdió sin renovar por cualquier razón o lo perdió por algún historial criminal, eso no significa que nunca puede arreglar su estatus migratorio. Eso significa que simplemente por el momento debe buscar una opción humanitaria u otra opción de legalización de estatus migratorio. Si ya se venció hace 4 años, típicamente van a ser soluciones humanitarias en vez de, por ejemplo, ser patrocinado por empleo, porque las restricciones contra gente quien ha estado fuera del estatus o quienes entran sin papeles, muchas veces la opción de ser legalizado por empleo no funciona bien. Cada caso es único, por supuesto, en una consulta podemos decidir qué es mejor. Ahora, por ejemplo, ¿qué será una opción humanitaria de legalización de estatus migratoria? ¿Y por qué no podemos simplemente renovar DACA hoy? ¿Por qué? Cuando su DACA se ha vencido hace más de 1 año, típicamente consideran una nueva solicitud de DACA como una solicitud inicial, no como una renovación. Y entonces estas solicitudes iniciales podrían estar rechazadas o pendientes por muchos, muchos años. Entonces no hay realmente muchas veces un punto de aplicar nuevamente para DACA. Pero donde han cerrado una puerta, vamos a buscar abrir una ventana y muchas veces la visa U o la visa T es una excelente manera de legalizar su estatus migratorio para ellos que les califican. Ok, cuando digo eso, gente dice, pero yo nunca reporté nada, nunca llamé a 911, yo no fui víctima. Digo, ok, está bien, quizás no estamos buscando la opción de visa U, quizás sí todavía porque puede ser reportes tardes, pero vamos a hablar más sobre qué es la visa T. Yo sé que hablo demasiado quizás de las visas T, pero las visas T cubren situaciones que DACA no puede ayudar. Las visas T tienen una opción de residencia permanente, un sendero a la residencia permanente después de ser aprobado para la visa T. Encima de esto, la visa T no requiere un reporte que pasó sobre la victimización anteriormente, sino que es algo que se puede hacer en un futuro para aplicar para la visa T. Voy a dar 4 ejemplos de casos de visa T que gente quien tenía DACA anteriormente han arreglado. Aunque se vencieron los permisos de Daca o si tenían Daca, es lo mismo porque no tiene que tener Daca para aplicar para una visa T. Y si tiene Daca, simplemente va a seguir renovando su Daca hasta que eventualmente tenga éxito con el estatus de visa T. Ok, ejemplo número 1, cómo aplicar para la visa T o calificar para la visa T. Si alguien ha sido víctima de violencia doméstica, abuso emocional, manipulación o abuso sexual, eso puede ser una forma de trata de personas. ¿Por qué? Porque violencia doméstica o abuso sexual es un crimen típico muy fuerte que tiene que ver con coerción. Y la coerción en la relación no es solamente que le está golpeando o abusando sexualmente, sino que la coerción extiende a las tareas en la casa. Esto puede ser servidumbre involuntaria. Un ejemplo, yo quiero cocinar, yo quiero cuidar a mis niños, pero si alguien me está amenazando con deportación o que me ha golpeado o algo así, entonces, las tareas que hago en la casa o cuido de niños o cocinando, entonces ya no es como voluntario, es involuntario porque hay consecuencias violentas o abusivas que pasan si no lo cumplo. ¿Ok? Eso es una cosa. Así que mucha gente quien ha sufrido violencia doméstica o algún abuso sexual, quienes no han reportado este incidente nunca en su vida, no es tarde tener una consulta sobre aplicando para la visa T debido a su victimización. Así que si algo así ha pasado, queremos saber. En una consulta confidencial. Y para aplicar para la visa T, nosotros típicamente manejamos el reporte para el cliente si no es una emergencia. Significa que muchas veces reportes tardes no pueden ser muy bien investigados, pero no tiene que tener una certificación de visa T para aplicar y no tiene que tener una investigación activa o prosecution para ser exitoso en un caso de visa T. Para aplicar para la visa T, típicamente es una declaración de víctima honesta, un reporte que hacemos, típicamente una carta breve informando a algún departamento de trabajo u otra agencia que la víctima fue victimizada. Y típicamente nuestros clientes participan en terapia y el programa de ayuda para víctimas de trata de personas. Así que el proceso de visa T puede resultar en un permiso de trabajo, acción diferida de víctima, y esta acción diferida de víctima es más poderosa que Daca. La acción diferida de víctima debido a la visa T pendiente significa que tiene un caso pendiente en buena fe y no puede ser deportado mientras está pendiente. La acción diferida de víctima basada en una visa T pendiente es válido por 4 años, no solamente por 2. Y típicamente la visa T, cuando está aprobado de ahí, tiene una opción de la residencia permanente también. Ok. ¿Qué son otros tipos de casos de visa T? No es solamente abuso sexual o violencia doméstica. También hemos llevado casos sobre religión, alguien usando religión para manipular a una persona a hacer cosas. Otra vez puede ser algún servicio o algún abuso sexual, pero sí hay abusos en la iglesia, no solamente en la iglesia, pero puede ser otro tipo de religión, ¿no? Y entonces esto puede ser trata de personas porque usan fe para tratar de controlar gente. Esto no es una situación que es normal para la iglesia, ¿no es cierto? Pero es algo que puede pasar, es una distorsión o algo incorrecto que está pasando y entonces califica para la visa T. Número 3, otra cosa que puede calificar una persona para la visa T es explotación laboral en el trabajo. Por ejemplo, algún trabajo no le pagaba a tiempo, mentiras sobre pagos, no pagándole sobre tiempo, overtime correctamente, amenazando con deportación o ponerle en la lista negra o acecho sexual o mucha discriminación o humillación en el trabajo, desarrollamos esta información para entender qué pasó y muchas veces estos casos de explotación laboral llegan hasta el nivel de poder hacer un caso de visa T. Y número 4, puede ser victimización por coyotes, los guías que le trajo a los Estados Unidos. Si le han cometido algún abuso, esto también podría ser posiblemente opción para visa T. Hay muchos diferentes escenarios, pero yo quería hablar de esto porque mucha gente trabaja en salones, restaurantes, limpieza, niñera, construcción, landscaping, pintura, en escuelas, en iglesias, en diferentes situaciones y simplemente no saben que la explotación que han sufrido no es normal, sino que es una forma de abuso laboral que le califica para aplicar para la visa T. Hemos arreglado mucha gente con Daca para estatus de visa T. ¿Por qué? Porque vinieron a ese país muy joven, muchas veces fueron abusados por los coyotes o fueron víctimas de explotación en un trabajo o tuvo una pareja muy malo que le abusó. Así que yo quería hablar de esto y decirle que sí, absolutamente puede aplicar para la visa T si su DACA ya está vencido. De hecho, DACA y visa T no tienen que ser conectados, pero estoy haciendo una presentación sobre DACA y DACA perdido, diciendo que mucha gente piensa que cuando han perdido su DACA, que no tiene ninguna opción. Pero al contrario, muchas veces perder DACA significa que la persona necesita otra consulta para buscar una nueva opción migratoria diferente de DACA. Y muchas veces es la visa T o la visa U que le califica a la persona para aplicar para algún beneficio. Así que, Elizabeth, me encantaría que haga una consulta con nosotros. Nuestro número de teléfono es 910-509-7145. Si quisiera una consulta, vamos a poner un poco más información en el chat en cómo comunicarse con nosotros si quisiera ver cuáles son sus opciones de arreglar. Okay, so we're going to go back into English. Vamos a hacer un poco en inglés ahora también. So we're going to go back into English, but one of the questions was, what do I do if my DACA expired 4 years ago? And normally at that point, your DACA is considered to be an initial application if you try to refile. And most of the time, not always, that ends up being a waste of time. So in a situation where DACA is expired, we're usually looking for alternative options like the T visa or U visa. And I gave some examples of how to qualify for a T visa. So, for example, if somebody was a victim of domestic violence or sexual abuse, harassment or severe discrimination in the workplace, false promises to pay, being paid late, being threatened with deportation directly or indirectly, being abused by coyotes, being abused in your church, being forced to do excessive chores in the house by abusive relatives. All of those are examples of things that often go unreported, but can qualify a person for a T visa. The T visa process, when you apply for it, you also ask for deferred action. So the deferred action for somebody whose DACA is expired or somebody with DACA who just wants to have a second option that's better than DACA. Either way, when we apply for T visa status, we're applying for deferred action for victims. We're requesting 4 years of work authorization instead of 2, which is awesome. If you have a pending T visa case that's pending in good faith and has gotten a bona fide determination letter, you cannot be deported while that T visa application is pending. And if the T visa application is approved, then you can apply for lawful permanent residency. So if you have DACA or if you have lost DACA or if your DACA is delayed, those are all great reasons to consider a consultation about the new 2024 regulations that increased and improved T visa eligibility for so many people, millions of people. And so if you haven't had a good T visa screen in a really long time or you've never had one, it's time to get one done because this DACA cycle of 2-year renewals and suffering delays is ridiculous. Okay, So then there's another question. DACA delays are affecting a lot of people. Are the delays permanent? Oh, that's such a great question. Boy, do I wish I had a crystal ball to answer it. I do think that these delays are going to continue for a long time, to the point where if somebody has DACA at this point, I think you'd be fine to renew it even a year early. 6 to 8 months at this point, totally normal to file a DACA renewal that early. Even if it means it might speed up later on, you just don't want to risk it. It's a very precarious or dangerous place to be in, where you don't have the DACA coverage, because that lawful presence is so important. It's not just about the work permit, it's about having that protection. I do think that this current government administration has done some major slowdowns unnecessarily. But I'm sure the government thinks they've got their reasons for it. At the same time, we're not seeing a difference in the type of applicant who's being delayed, which says to me, if nothing's really changed, and the applications are pretty much the same, and the background of the applicant is pretty much the same, and everything is equal to the last time for the renewal, there really cannot be a good reason for them to be this slow. And they increased the fees to file. The government increased its filing fees, saying they needed this money to process applications quickly, and then started processing them slowly. So I do think we're going to see these delays for a long time. And I think unless somebody starts doing a group lawsuit, like major litigation about the DACA delays, we're not going to see a lot of progress anytime soon. So contacting congressional representatives for accountability by USCIS can be helpful, but those are often individual requests. Until a group lawsuit or class action or national effort is basically forced upon USCIS, we usually don't see them starting to speed up anything. Once they do speed up DACA applications, if that pressure gets on top of the government, then what do I think will happen? They'll start slowing down on some other type of application, and it'll start all over again for whoever is experiencing slow adjudications there. Also, I just wanted to say that DACA applicants are not alone. They have slowed down U visa processing. They have slowed down T visa processing. They have slowed down DACA processing. They've slowed down I-601 processing. They've slowed down VAWA processing. Everything across the board is slower these days, despite USCIS filing fees having increased. So we do have to prepare to file renewals very, very early. And I am so sorry. I know it is incredibly, incredibly unfair. So thank you so much, Amigos 182, for your question. I appreciate it. And again, if this has been helpful to anyone, please give us a like, a follow. On Facebook, you can send us stars. It helps us improve and expand our programming. But on YouTube, subscribing and sharing is the biggest thing you can do to support our informational programs. Hay otra pregunta de Elsa. Vamos a hacer esta pregunta. ¿Qué puedo aplicar para la visa C? Llevo años esperando por la visa U. Muy buena pregunta. Hay mucha gente con visa U pendiente y quieren también intentar un caso de visa C debido a haber sido víctima de trata de personas, como le dije anteriormente, abuso laboral, abuso físico, abuso sexual, que llegó hasta el nivel de trata de personas. Si alguien lleva un caso de visa U pendiente por mucho tiempo, absolutamente vamos a querer considerar metiendo un caso de visa T también. Es un tiempo largo para esperar para las visas U, porque hay mucho más solicitantes comparado a solicitantes de la visa T. Sin embargo, también puede tomar 6 meses hasta un año más o menos para meter un caso de visa T. De ahí otro quizás 8 hasta 16 meses para conseguir la carta de buena fe y permiso de trabajo y acción diferida basado en la visa T pendiente. Y generalmente 29 meses para una decisión final para estatus de visa T. Así que yo sé que para ahora es gente con DACA están diciendo, pero si estoy como 2-3 meses para llegar mi permiso de DACA, ¿por qué voy a esperar 29 meses para estatus de visa T? Pero el punto que hago es esto. Cuando hay un problema con DACA, que se repite cada año y medio o 2 años, tenemos que abrir otra puerta o otra ventana. Y eso sería empezando típicamente otro caso de la visa U, la visa T o VAWA o un caso de negocios o inversión o algo así para que tengamos como otra opción. Okay, amigos 182, you just totally made my day. Thank you for answering and your empathy. I have so much empathy for what is going on here. I have 26 years of experience in the immigration system. I have learned to become a very patient professional, but I am not a patient human being. It is insane for these cases to be taking this long. DACA approvals should take 24 to 48 hours. They should not take any longer than background checks need to run. And the vast majority of background checks can fully and completely be done in 48 hours. There's an online application process for DACA. It's fully streamlined. There's really not a lot of difficulty that the government has to go to approve your cases. So when I see people who have done everything right, with or without a lawyer, who are stuck waiting for their work permit, it makes me crazy. This is not the type of application that should be jamming up the system. It should not be stuck. There are cases that are really complicated. Like, for example, T visas are not just, again, for people who have had DACA or who have it now. We handle T visas for people with multiple deportations, with serious criminal histories, with a lot of entries and exits that were unlawful, with false claim to US citizenship, with a lot of problems. Those can be very complex cases. They're not always simple cases, right? I can understand why a T visa might take some time, but it shouldn't take 29 months. Like under the previous administration, under Obama, we were seeing T visa approvals come out in 3 months. So if they could do those in 3 to 4 months under Obama, there's no reason they can't do them under this administration. Even under the Biden administration and previous Trump administration, where there was a lot going on with the pandemic and COVID delays and all of that, we were still seeing T visa approvals in like a year. So to see something like this, where we're now doubling the processing times, even though they still haven't approved 5,000 T visas, the processing times are just unacceptable. So I'm living through these long delays with my clients on a regular basis. Our employees at our law firm in Wilmington, we're handling the customer service calls. We're working on congressional liaison and expedite requests. We see the extra work and frustration that people have to go through to get the exact same thing that they got much more easily 2 years before, or 4 years before, or 6 years before. And it is super frustrating. And my heart goes out to you. You do not deserve to have to go through this. But I hope that some of the tips I've given today related to trying for expedites have been helpful. And, they say everything happens for a reason. Well, I don't think DACA delays are happening for a reason. That's a good reason. But if there's anything good to come of this bad situation, if we can like sacar algo bueno de esta situación, it would be that people who are listening today, who are listening because of the problem with DACA, consider going, you know what, I am going to finally do a T visa screen. I want a T visa screen, U visa screen, full comprehensive screen. Maybe I find something better now this time around, because new regulations did actually come out in 2024 that made the process better. They're like amazing regulations. I'm so proud of the professionals in government who created the final T visa regulations. They did a really good job. So we want people to look for those new opportunities. And again, what I usually tell my T visa clients who have DACA is you're going to keep renewing DACA probably another couple of times until we get through your T visa process as well. But once you lock in on T visa status, then that opens up the door to the green card. So I know we might have some more questions. If anybody else wants to ask another question, I'm certainly available. Si alguien quiere otra pregunta, estoy aquí para poder contestar. But I did want to say that we have some things to add to the chat because we do have lots of free videos about different types of immigration options. So if you're still nervous about booking a consultation with us or someone else, about having a T-screen or something like that, you could watch our free videos on our website. We also have even more videos on our YouTube channel. And I would just love for folks to check out our YouTube channel because I have worked super hard on trying to get more information in Spanish. There's a Spanish playlist. There's also an English playlist, and there's an English and Hindi playlist. So we have it in 3 different languages, lots of different videos for people to really learn. And they're not like 2-minute videos. A lot of the videos are, like a webinar, like what I did today, where I spent an hour talking about things. So you can really learn a good amount of information um, uh, in depth during the process. Okay, so then I'm going to put this information about our consultations in the chat here, so you can find this later. Again, I also just put in what are the YouTube channels that you can watch in English and Spanish, and then our consultation prices and phone number there if anybody wants to book. Si quieren alguna consulta, tenemos información aquí en el chat. I also just want to say that we do have a military discount. So if you are in the military, or you have a spouse, a child, parent, or fiance in the military, we do have a discount for those consultations, which is super exciting. We just started offering those in March. So each month we're deciding what we can do there. Try to keep the discount going as long as we can. And then also you'll see in the chat here, I'm sorry, I'm trying to copy and paste, so it's taking me a minute. There we go. We have a new office address. Our office has moved to 1501 Medical Center Drive, and after many, many years in Mayfair, we finally bought our office building. We're super excited about it. But just if people are contacting us, be aware that we do have a new address. And then also, I'm going to put this information about our the Facebook Star program. Whenever we get stars on Facebook, then I usually get a message from Facebook saying they're going to increase our reach. And then that allows us to get these live programs out to more people, which is very cool. Okay, so then I think I've put everything in here that we need to share. The other stuff that I had here was more related to an old military PIP program. But we do have a YouTube live in Spanish and in English on the military PIP programs and what is going on there. All right, so then we still have a couple more minutes. Si hay alguien que tiene una pregunta más, estoy aquí para contestar. Como siempre, me encanta su apoyo de nuestra oficina. Nosotros queremos el trabajo que hacemos mucho. El equipo es muy trabajador. Si alguien tiene un caso, vamos a avisar. Si pensamos que no hay un caso o que no puedo tomar el caso porque es demasiado riesgoso meter el caso, vamos a ser honestas en nuestra respuesta. También muy importante, por favor, que no usen notarios o paralegales sin supervisión de un abogado. Esto puede perjudicar su caso muchísimo. Otra cosa, si tiene Daca, por favor que miren su número A, su USCIS number, su número A en su caso, y verificar si tiene alguna orden de remoción en su record, o si fue cerrado por lo administrativo, tiene que doble chequearlo. Porque hemos visto que muchas veces gente no sabe que tiene esto en su récord, especialmente si vinieron como jóvenes o si los padres o familiares nunca le dijeron qué realmente pasó en la frontera o qué pasó cuando aplicaron y fueron rechazados para otro tipo de caso como asilo o algo así. So just a final ask for people who are listening today. Please, if you have DACA or had it in the past, look at your work permit or your previous DACA approvals or receipts and look for the A number. Sometimes it's called a USCIS or DHS number. Often it's an A number. It's usually 9 digits. Sometimes it's 8. Sometimes it's 7. And go into the EOIR website. And I'm going to put the EOIR website for case status in the chat. And you want to plug in your A number. And then you want to just check your status, because sometimes people don't know that they have a deportation order against them or that it was administratively closed. Sometimes the government is recalendaring or putting people back on for immigration court without them knowing, even though they have DACA. There's some crazy stuff happening that makes no sense at all. This is not to scare anybody. This is just to say we're a law firm. So, like, a hospital has an emergency room and they see the worst situations. And so we're a law firm and we're kind of like that emergency room where we see the worst situations. So sometimes you're going to see things like the government sending a notice to the wrong address and someone being ordered deported. We had that situation. We just got that deportation reopened for somebody. They had never gotten the notice of the court hearing. So, you want to go onto that website, please check your A number and just see if it says anything connected to your name. If there's no case number found, that usually means that there is no deportation or removal case connected to that A number. Sometimes people have had more than one A number or don't realize that they've had more than one A number. So that's a whole nother story. But overall, this is a very useful tool to see if there might be some type of removal history there. So I hope that I've been helpful. I think, let's see if I answered all the things I hope to cover today. I wanted to cover what to do if your DACA renewal is delayed. I think we talked about the expedites pretty well. How to avoid gaps in status, right, and protect your work authorization. We talked about filing early, even though it seems nuts to have to file that early, and even though it's super unfair. We talked about what to do if your DACA is denied. If it's denied, you want to see an attorney and see what alternative options do you have if DACA has been denied a long time ago. If it's more recently denied, then sometimes a refile or something like that can happen as well. We wanted to talk about why denials can happen sometimes, and we covered that. And we also talked about if you've lost DACA, looking for different immigration options. So don't panic over the delays. Don't do nothing after a delay or a denial. You don't want to rely on incorrect or incomplete filings. We really want to have a good strategy. Oh, we got another question. Thank you so much. Amigos, you're being my amigo today. Thank you. Should we check every month? I think it's a good idea, but not to be like paranoid about it. So, like, you can set a reminder on your calendar to do like 5 things every month, right? And then that way it's just like one of the tasks you knock out, and that kind of keeps things a little more chill. So, to check every month your bank balances, check every month your A number on EOIR, check every month if the air filters in the house or something else around the house needs to be fixed, like some type of house maintenance issue. So just make it like a maintenance thing that you're just going to check on that once a month, along with other things you want to check on that just help improve your everyday life. And then that way it becomes ordinary instead of something that you stress out too much about. And then if you do see something pop up that you're like, what is that? Then you definitely want to see an attorney about it if you don't already have one. These were not problems that we saw under previous administrations. So this is very much a like now kind of happening thing. And it's something that may not last forever either. So as we see future changes in politics or presidents, the checking once a month thing may not be something that people necessarily have to do in the future as well. So this may not be a rest of life situation. So great question. Okay, we got one more question we'll take today before we wrap up. So thank you so much for asking. Let's see, the question from Veronica is, if someone has a final order of removal after losing asylum in 2014, and you now have a T visa pending, but ICE may not wait for the T visa to be approved, what can you do? So the concern is, could I be deported while the T visa is pending? So in a case like that, the first question I would have is there a bona fide determination? So is there a bona fide determination on the T visa that's pending? If your case hasn't been pending that long, you may not have one. But if your case for T visa status has been pending more than 6 months, you do have an option potentially to file for mandamus, which is a electronically filed lawsuit. It's not an immigration court. It's a lawsuit in federal court. These are very common lawsuits. They're not lawsuits trying to get money. They're lawsuits trying to push forth with getting a full T visa adjudication or bona fide determination. Because once you get a bona fide determination letter, then you cannot be deported while your T visa is pending. There was one case I heard of about a year and a few months ago where somebody was deported despite having a bona fide determination on a pending T. And their awesome lawyers sued the government, and the government had to pay for their tickets and get them back into the United States to see out the rest of their T visa case. So it is a very powerful law. Can mistakes happen? Yes, but the law can be very protective. Um, Okay. So then if you have a bona fide determination, it looks like that person does, then and an ICE officer is saying you may still have to go because that doesn't give you status. That is concerning. That is definitely a conversation for your attorney. Sometimes there has to be some education of the ICE officers. So, for example, presenting them with a potential complaint or demand could be very helpful. The ICE officers may not have an appropriate level of training. Remember, out of millions of people in the United States, less than 5,000 people each year get approved for T visa status. So I talk about T visas all the time. I wrote a book on T visas. I teach T visa classes. T visas are like a huge part of our immigration law practice, along with all the other types of cases we handle. But for ICE officers, T visas are like this tiny weird thing that they just don't know a lot about. They also may not have actually read the 2024 regulations that are extremely clear about what a bona fide determination does. So I would want, as the attorney, to start getting some stuff in writing related to the bona fide determination, and also consider the mandamus option to try to push forward to a final determination in your actual case. So I certainly have some recommendations. Typically, Jesse Bless, he, like me, graduated from Wake Forest School of Law more than many years ago. I'll be an attorney now, 20 years this fall. But anyway, we've done a lot of mandamus work with Jesse Bless. He's very good. But check with your attorney. It sounds like if you've got a bona fide determination, that's already a really good thing. And so now the issue is communicating with a low-level ICE officer who needs some education so that they can do their job more correctly instead of illegally send you out of the country. Okay. Oh my goodness. And you're a nurse and have been here for 25 years. So okay, my mom was a nurse for like 40 years before she retired. I'm a big fan of nurses. I love nurse cases. Thank you for what you were doing. You are there the day to day that people need more than anything, because immigration papers are one thing, but if you don't have your health, then those papers mean nothing. So thank you for the work that you're doing as a nurse. Huge shout out to all the nurses there. I definitely think this is something where there's an intervention that can happen to help protect you. And thank you so much for asking this question today. That is awesome. The 246 day can be, yeah, absolutely. That's certainly something to look at, the I-246 day. The thing is, your bona fide determination says that, like, if you look at your bona fide determination notice and just read it out loud to them, it literally says any order of exclusion, removal, or deportation is hereby stayed while the application is pending. So you already have a stay essentially because of that, but you could still do a 246 as well. It's kind of like feeding them something they might understand better because they're used to people submitting 246 days. But the other thing about an I-246 day is if you don't need one and then you're submitting it, I wonder if you would then start making them think that other people need to do that. And then it can get kind of expensive, for people to do this when it may not actually be necessary. So definitely want a lawyer's involvement here. These are conversations that if you're trying to argue with the attorney if you're trying to argue with ICE on your own, you're generally not going to have the same level of success as an attorney who can threaten much more serious action against the ICE officer, including different reporting lines, AILA liaison, all of that. So, yeah, ICE officer being new and very young. And, I'll be honest, like, I've been teaching about T visas for a very, very long time. I think we had our first seminar in 2017. Of course, I was doing T visas before then. So a decade of this work or more. And every day I still come across even immigration attorneys who don't know about T visas and what they can do, or immigration lawyers who don't even screen their Daca clients to see if they qualify for a T visa. So I wouldn't expect ICE to know everything either, if even immigration attorneys still haven't really built T visas into the normal standard of practice. And yet I hear about TVs of fraud. I hear about people are making up cases and filing stuff fraudulently. In the same way, I hear people are making up asylum cases or making up a VAWA case or making up some other type of immigration case. There's always going to be some level of malpractice or fraud. We need to combat that, right? We want the good cases to get filed and approved. And if people are doing something wrong, we want to make sure that they stop doing that, right? Same thing with ICE officers. We want to make sure that the ones who don't necessarily have the best training at least get the information that they need. Or you go over their head to a supervisor to give them the information that they need so that they don't make a mistake like deporting someone who cannot be deported when they have a bona fide determination. So that's a great question today. Thank you so much for asking. And I know we're over time, so thanks for all of you for hanging around and listening a little bit longer today, especially as we got off to a slow start. Again, my name is Helen Tarokic. I'm a North Carolina board certified immigration law specialist. I'm a licensed attorney in the state of North Carolina. Our law firm in Wilmington, North Carolina takes all kinds of immigration and citizenship cases. We do a lot of work on humanitarian relief like Daca, U's, T's, VAWA, but we also do business immigration, marriage cases, and family and other type of work. So if anybody needs information, our number is 910-509-7145. The biggest thing you could do today to thank us is to like, follow, or share our program. The biggest thing we're trying to do is just make sure that people have information. And then if you are on Facebook, you can send stars. That also helps promote us as well. In the meantime, I wanted to also say that we are going to have a new session coming up soon, and it's going to be about U visas. Lots of people have U visa issues. We're going to do everything we can to answer those questions coming up later this month. So you can follow us and look for our next upcoming events. And then again, don't forget to check out our free videos at tarokiclaw.com/videos. Have a great rest of your day and hang in there. America is a nation of immigrants. Y'all are awesome. You deserve to be in this country. We are here to help. Thank you.